Good evening, everyone. I would request all my friends to please be seated. A warm welcome to everyone. I will request our esteemed speakers to kindly come to the dais. And can I request Mr. Talveen to please escort Honorable Justice Manmohan to the stage, to the dais. Can I request Mr. Rahul to please escort Justice Shakdar to the dais? Can I request Abhas to please escort Justice Sachdeva to the dais? I'll request Mr. Sanjeev Balyan to please escort Justice Chawla to the stage, to the dais. And can I request Maninder to please escort Justice Prasad to the dais? Thank you, Maninder. We'll start this evening's program with the national anthem. I'll request everybody to kindly stand.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Honorable Justice Manmohan, Acting Chief Justice, Honorable Judges on the dais and off the dais, Mr. Chetan Sharma, Learned ASG, Mr. Mohit Mathur, President, Mr. Jatin Singh, Vice President, Mr. Sandeep Sharma, Secretary, and other office bearers of Delhi High Court Bar Association, my colleague mediators, friends, ladies and gentlemen, I'd like to wish all of you a very happy New Year and a happy Makar Sankranti. We have gathered today for the launch of this unique calendar, which has been, I think, in the 13th year of its release in 2024. And this is coupled with a symposium on mediation practice and advocacy, embracing the change. I'd like to have the views of our esteemed speakers on that. I would like to remind you that last year in April, we had a unique, first of its kind national conference under the chairmanship of Honorable Justice Manmohan on mediation at the dawn of golden age. And it's very vivid in our memory. And we look forward to having many more such programs in the year to come. I would like to welcome Honorable esteemed speakers on the dais. And can I request Mr. Mohit Mathur to please come forward and welcome Honorable Justice Manmohan with a potted plant. That has been our tradition at Samadhan. I'd like to request Mr. Jatin Singh to please come forward and welcome Honorable Justice Shakdar. I would request Mr. Sandeep Sharma to please come forward and welcome Honorable Justice Sachdeva. I would request Mr. Shyam Sharma to please come forward and welcome Honorable Justice Chawla. I would request Mr. Maninder Singh to please come forward and welcome Honorable Justice Prasad. I would now like to invite our organizing secretary, Ms. Veena Ralli, to please come forward and give an introduction to the calendar.
Good evening, everyone. Honorable Mr. Justice Manmohan, the Acting Chief Justice, Justice Shagdar, Justice Sachdeva, Chairman Overseeing Committee, Samadhan, all the honorable judges on the dais, off the dais, Mr. Chetan Sharma, Additional Solicitor General, Mr. Mohit Mathur, President of our Bar Association, Mr. Jatan Singh, Vice President, Mr. Sandeep Sharma, Secretary, and all other executive members of our Bar Association, senior advocates, mediators, friends, ladies and gentlemen. I also wish everyone a very happy new year. As you know, Samadhan gets its own calendar made ever since 2011 and puts in lots of efforts in planning and designing the same. Calendar of Samadhan is much more than what it portrays. For Samadhan family, it is a reflection of our commitment to empower the parties to find closer to their conflicts. Our calendar finds center space on every table in mediation room and works as a silent but effective participant in the mediation process. Each year's calendar is carefully thought and every effort is made to pick up a relevant theme and that illustrates an important aspect of mediation. Different quotes with matching photographs are then strung together to capture the chosen theme for all the 12 months. We have had made every effort to see that we have a special theme for our calendar this year as well, and chosen topic is emotions. Careful handling of which can make a lot of difference in the attitude of the conflicting parties. Actually, handling emotion goes a long way, even beyond resolution. As mediators, often we see parties overwhelmed with emotions who dig into their positions. Mediator needs to listen, reflect, and express empathy while identifying the emotion and giving legitimacy to them. Understanding and learning to manage emotions is basically the basic purpose of mediation. Mediators at Samadhan recognize the importance of diffusing emotions before getting into the actual zone of problem solving. May I request Honorable Justice Manmohan, the Acting Chief Justice, to kindly release our calendar. And may I also request Mr. Mohit Mathur to please come on the dais for release of the calendar as well. all kudos to Kiran Kalra, our calendar coordinator, and our designer, Mr. Vinay Jain, who have made it possible to have these excellent pictures to express the messages accompanied by the quotes selected in line with the theme of the calendar. Dr. Abhimanyu Chopra has made this beautiful PowerPoint presentation, well coordinated with the music composed by my one family friend, Dr. Sujit, who we lost during COVID. I thank his family for giving us permission to use his composition also. I'm sure the user of this calendar will encourage us to create another beautiful calendar next year. Thank you very much.
Thank you, Veena. I would request Honorable Justice Chawla now to please elicit the views of our esteemed speakers on the topic of the symposium, Mediation Practice and Advocacy, Embracing the Change. Thank you. Good evening, everyone. As the topic of the day,
Okay. Good evening, everyone. As the topic of the day suggests, mediation practice and advocacy, embracing the change, is all about how the advocates embrace mediation process and can work in its success. And I think the biggest example of that is our own mediation center, the Samadhan. I think its success is owed mainly to the advocates who are the trained mediators and who participate in the mediation process wholeheartedly and have made it a tremendous success for the entire country to emulate. But with the changing times, there are certain new nuances which need introduction. There may be specialized training, specialized topics that need to be introduced into mediation. So I would be asking my esteemed panelists about their views on what further needs to be done to improve the system as far as advocacy and practice of mediation is concerned. I will start with Honorable Mr. Justice Manmohan, our Acting Chief Justice. So what according to you is really the mediation advocacy? Because there is mediation and there is advocacy. How do you merge the two concepts together and make it a success?
Before I start,
that little thing you switch on. No, you need to switch that.
before I start, I'd like to congratulate Justice Sachdeva, Ms. Veena Rali, Ms. Kiran Kalra for the beautiful calendar they have made. And I think they always do us proud. So thank you very much to the Samadhan team for preparing a beautiful calendar. It always remains on everyone's table, and it reminds you of a lot of issues which are there in this society. And this year, the topic that has been chosen, I think, has been chosen very wisely, because everything is concerning emotions. In fact, most of the litigation that you find that takes place in the courts is arising because of some emotional entanglement that takes place between the parties, and they are disturbed by the emotions. Having said that, the issue that you have raised about mediation advocacy, I would like to say, or I would like to explain it in a slightly different way. I would like to compare it with the practice which normally the lawyers do in courts. See, we as lawyers are always trained to strongly defend the position that our client has taken. And the intent is to always win and to prove that your client is right. we always take great pains to ensure that his point of view is put across properly, and wherever there is a doubt, that doubt gets decided in favor of your client. But mediation advocacy is slightly different. There, you're not trying to ensure that your client wins. There, you're trying to ensure that the underlying dispute that is there between the parties gets amicably resolved. See, the issue in mediation is that the canvas is far wider. You can ask for a relief which has not been prayed for. And at times you find that in certain litigations like family litigation, whether it is partition or domestic violence, the real issue that is hurting the parties cannot be brought forward in litigation. The underlying dispute cannot be agitated and adequate relief cannot be sought with regard to that underlying dispute. So here you have a forum where you can redress that grievance, and you can look for a creative solution, which can be an out-of-the-box solution, which a learned judge may not be able to give. For instance, a judge can only deny or grant relief that has been prayed for, but he can't think out of the box and grant you something which may resolve the problem in perpetuity. Therefore, the role of a lawyer in mediation process is very unique. And to my mind, it is very, very pivotal. The role is different at different stages, whether it is prior to mediation, during mediation, or after mediation. And the most important thing which a lawyer can do, and what mediation advocacy is all about, is moving your client. In the sense, changing the stance of the client. The rigid stance which the client may have taken in court, you move his position. And you ensure that his movement which takes place benefits not only the client, but also addresses the underlying dispute, and in the process may also benefit the rival or the opposite party. Now, when you see his role, the mediation advocacy role, at the pre-mediation stage, he has to explain the mediation process, for instance, to the client. Then he will also have to ensure that he prepares the client and makes him open to mediation. He addresses whatever misgivings he has with regard to the mediation process. He tells him what are the advantages in the mediation process. For instance, the solution can be an out-of-box solution. It may address the underlying dispute which has been bothering the parties. Then, when it comes to during the mediation process, there also he can play a very major role. He will always play a supportive role. In fact, one thing is there, and which we would like to emphasize, and that's what we felt when I was in charge of Samadhan, that many lawyers during the mediation process send their juniors to attend the mediation hearings. In fact, it's a very crucial phase of mediation. The lawyer must be actively involved during the mediation phase, because what he can suggest to the client how to deal with the underlying dispute that no one else can. Then the creative solutions that a lawyer can come out with, I don't think any party can even think about those solutions. Then after the mediation process is over, how to frame the mediation agreement to ensure that it does not lead to further disputes. That itself is an art in itself. So it's very different from litigation practice. Then he has to ensure that the agreement that has been agreed upon gets implemented, gets enforced, so the parties get the desired results. So mediation advocacy is quite different from what we are used to, wherein in courts where we are putting the best case forward and we are taking a very strong position. Here we are not taking a strong position. We are trying to address the underlying dispute and trying to move our clients to ensure that a resolution is arrived at and that addresses the main concerns of the parties and ensures an underlying or an everlasting peace that is achieved between the parties.
Thank you. that is true that the role that an advocate performs as far as mediation and in the litigation is concerned, it is vastly different. And so you have rightly highlighted what all is actually required of an advocate when he is coming into mediation and preparing his client. In fact, that takes me to the second question which I will address to Justice Shakdar. So according to you, is there any special approach that a lawyer must have while preparing his client for mediation, and especially when he is going for a pre-institution mediation? Do you think that there are some special requirements that are required? You know, the client does not know what is mediation. He only knows that he's gone to a lawyer for a litigation purpose, and now the lawyer is telling him for a mediation. So is there something special which a lawyer must do, an approach adopted for his client?
Yeah, before I answer that question, Naveen, I will join Justice Manmohan in emphasizing that what a wonderful job that the mediation committee has been doing for over the years. I think our mediation center is one of the best in the country, and we have these lovely mediators over here. I see some old faces and some new faces, and that only shows that more and more people are gravitating to mediation. In fact, some of the retired judges these days prefer mediation to arbitration. And the reasons can't be monetary. I think the reasons are, and which is what drives perhaps lawyers also to mediation, is somewhere it gives you more satisfaction. So to answer your question as to how should a lawyer prepare his client for mediation, to my mind, the most essential thing that the client needs to convey, or rather the lawyer needs to convey to his client, is that in a list where you are in court, someone is judging you, and no individual likes being judged if left to his own devices. So he needs to tell his client that here is a person who's only a catalyst between the two disputants. He's not going to judge you, he's going to identify issues for you, perhaps. And then the disputants will have to arrive at some kind of a settlement if it's possible. If it's not possible, then parties are left at least knowing as to what is the core and the central issue troubling them. Now, ideally, sometimes it is, the lawyer needs to sell this to a client, in a sense, someone who's not been exposed to mediation, by telling them, what are the benefits of mediation. And so the mediators are concerned, they know what the benefits are. That there is a final resolution of the dispute if it is taken out of the litigation stream, if there is a settlement, it's efficient, it's cost effective, rules of evidence don't apply, and you are the master of your case. The lawyer is actually on the sidelines. The lawyer comes in only if there is some legal issue which he needs to explain to his client. Otherwise, you are, i.e., the client is driving this process. And it is both challenging and satisfying if you are able to arrive at a settlement. The last point that I want to underscore when you sell this to your client is the element of confidentiality and the possibility of repairing your relationship with the other side. See, if you settle, whether it's a personal relationship or a commercial relationship, it is no longer fraught, it settles, and maybe you're able to move on in life. I see this a lot in matrimonial cases. This is the jurisdiction that I'm handling apart from other. It's a gift from my Chief Justice here. And it's been draining me and my brother judge. But when we get a settlement, it is, believe you me, one of the most satisfying moments of the day, depending on the frequency. But it is therefore incumbent both on the lawyer and perhaps when it comes to the court, the referring judge, to be able to tell the clients if they are in court as to what are the benefits. So if you prepare your self for mediation, you will be able to tell them what the benefits are. But if you don't take these trainings, you will not be able to tell them, and they'll be reluctant to go there because they don't understand, why are you being sent out of the court system to a parallel system, and why should they go there? And especially if it's a state, driven mediation, which it is here, there's no cost to the litigants. It's only when you go to a private mediator that you have to pay a huge amount of money. So those are all benefits that you need to tell them.
Well, that's right. As you rightly said, as a lawyer, you actually become a salesman and you have to sell the mediation process to a client. And therefore, you need to highlight what all is actually the benefit that the client is going to get if he adopts a mediation process in a right spirit. So that actually now brings me to the next question, which I'll address to Justice Sachdeva. Now that you have to sell the mediation process, our training as a lawyer is very different. We actually probably sell litigation. And we tell them that, litigation is the right process. The court is the only authority where you'll get your justice. So when we are selling mediation now, is there a special skill set which is required for a lawyer to be selling it?
Well, certainly.
Or to even be practicing it?
Taking a cue from what Chief Justice Manmohan mentioned, that when a lawyer goes into court, he goes into court to win the case. So we have, as lawyers, the mindset of win-win situation. Now, this is the only center in the country which is run by lawyers. And it is very difficult to suddenly change your hat. Like you've all gone through the mediation training program, at least some of you have, where they give you an example of hats. You're given one hat which is a different color, which is the hat of a litigator, and then another hat of a mediator. And that is exactly what you all are doing. You go into court to argue a case, to win that case, and suddenly you come out and you're going into mediation with a different skill set altogether. So in mediation, actually it's again a win-win situation, but the goalpost changes. Goalpost changes from winning one case to winning the entire dispute between the parties. Because after mediation, the parties have to go back feeling that, look, we won. The dispute is settled to our satisfaction. Both sides have won, and not only that dispute, all offshoots from that disputes get over. In mediation, we know when you refer one dispute, you also say, all right, let's bring in everything else. Relations get restored. Parties dispute future relationship, even in commercial disputes. They get restored. Matrimonial disputes get resolved. So parties move on with a clean slate. As a skill set, well, lawyers will have to understand, and most of you have, our experience has shown, initially, I don't know, some of you may remember that there was a lot of opposition to this center. The feeling was that we will lose out on our earning. But that's not what this center has proved. It's proved that the lawyers who've actually gone and got cases settled through mediation, I was a mediator. And when you go back, getting a party a dispute resolved in mediation in such a shorter time, that they come back and say, look, this lawyer is good, he knows when to guide you. He knows that instead of litigation going into court, you may win that case, but then there is a possibility of an appeal. Appeal process will take several years and the result may be upset. But in mediation, when the settlement takes place, you go back, the lawyer remembers, the litigant remembers that this is a lawyer who correctly advised me to move on to mediation, got me the result there, and now if I need to go back to a lawyer for another dispute, who will he choose? Of course, somebody who's got him a result in the shortest possible time and long-lasting result. So the skill set that we require is we need to change the hat. You change the hat, you've sold, as Justice Chawla mentioned, sold mediation to him. And it's become a lasting possession for him. So next time there is a dispute, he'll come back to his lawyer and say, let's try pre-litigation mediation. Maybe take me a step backwards, and I might get the result in this juncture in that shorter time. So skill sets, as lawyers, yes, you will need the skill set of listening. As a mediator, you'll have to don the hat of what we do. We listen to you. As a lawyer, you'll like to argue. But as a litigant, and most of the lawyers also do, when the client comes to you for the first time, you adopt the skill of listening. You listen to his problem and then try and find a solution. So there are several skill sets. As lawyers, you can only need to sort of change the direction. But the same skill sets that you have as litigants, remember that the goalpost is changing. So same skill sets will lead to a different result. And again, you have to convince your client, you have to convince the other side in, yes, what is the correct win-win situation for both.
As rightly said by Justice Deva, actually there are two hats that you wear and you have to remove one to become successful in the other. But as he rightly also said, that once you've experienced mediation, a client has experienced mediation and the success thereof, it's easier to convince him on the second time round because he's already tasted that success. But for a new client who walks into a lawyer's chamber, he normally has come with a very stringent mindset. He feels that he's been wronged. There is a commercial dispute where he feels that the other side is owing him money which he's not paying. Matrimonial dispute where the other party is totally taking a arbitrary stand. All faults are of the other party. So there is very stringent stand that a client has taken, and that's when he walks into a lawyer's office expecting that the lawyer will just stand up, say 1, 2, 3, 4 litigations, and we'll teach the other side a lesson. Now, in that kind of a mindset with of a client, what message would Justice Subramaniam Prasad give to the lawyer? How to change that mindset and make him understand that no, there is, apart from litigation, there is something else actually.
So let me first begin by saying kudos to the mediation, to the entire Samadhan team for doing such a wonderful job and rather taking a good burden from our boards and solving a number of disputes. So, having said that, see, traditionally when the courts or the tribunals were the only form of justice dispensation, when a client comes to a lawyer, normally the lawyer makes the client comfortable by saying, you have the best case in the world. I'll win it for you. Now that raises the expectations of the client. That's one. Second is the client himself comes into the lawyer's office full of the entire case saying that I want this. A wife coming and saying I want 2 crores. An elder brother coming and saying that I was the one who has taken my father's business to heights. The younger brother was even in school. He's now coming and taking a share of the profits and therefore he must be out. At that point of time, traditionally, a lawyer would say, you have the best case. Now, with the advent of mediation, so the first duty of the lawyer is to inform the client that there are other methods also for a dispute resolution. Now, at the same time, when he informs the client about the other methods, he should not let the client lose the confidence in you to say that probably you don't have confidence in my case and therefore you're pushing me to mediation and I don't have a case, because the chance of the client will leave the lawyer and go to some other lawyer. So it's like a mother feeding her child by showing the moon, saying that look here, and you have to sell that what is the purpose, what is the benefit, which can be done after understanding the client, his requirement, his need, what is the best for him, and then probably tell him what is the best method available to you. For doing that, instead of bringing the client down or trying to sell or push mediation down his throat, you have to tell the client where you stand very politely, nicely, so that he understands his pluses
He's, as I said, trying to feed the child by showing the moon to say that probably you might not have such a good case with which you think. There is also a method by which we may be able to achieve X, Y, Z, which is your requirement, which may also need to further results. Now, this could be a difference when a when a plaintiff or a petitioner comes to you, or after the case has been instituted when a defendant comes to you. Both cases, the treatment would be different because the need of the client would be that there's an injunction against me, I want the injunction to be removed. So he comes and says, I can get the injunction removed fast, but you probably would know that by hitting the court, the time that will be taken to get the injunction removed, it's easier to suggest that probably by another method, I would be able to get my relief faster and quicker. So you have to show the client the mirror. You have to tell him what his case is, slowly, but surely in a method that the idea of mediation gets imbibed into it. There's another problem. Now, suppose you tell the client that he has the best case, and then many statutes provide for a settlement or a mediation process. And suddenly you can't turn around and tell the client that now go and settle, because you have told him they are the best case. And now suddenly telling the client that no, probably go and settle, the client might feel let down. So therefore, when a client comes to you, either as a plaintiff, petitioner, or as a defendant respondent, you have to assess his requirement, assess his need, find out the best solution, and then refer him to mediation. And also, by showing a reality check, you make him prepared or to be acceptable to the idea of mediation.
Yes, that's so true. Once you've told a client that you have a 100% case, then to tell him that no, settle at 80 is very difficult to sell. So definitely you have to tell him what his pros and cons are in the case. And that is how you will be able to actually encourage him to mediation process. And given the kind of, I'll say, discretionary powers that the court has, also probably have to be told to him. But that now brings me to a different topic. We now are all in the agreement that advocate plays a very important role in the mediation process, both as a mediator, as also a person who's preparing his client to go towards mediation. With the expert field of practice that now is developing, we have practitioners on income tax side, we have practitioners on IP side, the commercial side, criminal side. There's more and more of, I'll say, domain expertise which is developing. Do you think that in mediation also, having this domain expertise is going to help a mediator perform better? And a time is likely to come where mediators are chosen with their domain expertise.
You see, this will have two sides. Now with institutional mediations coming up and pre-litigation mediation developing, in an agreement between two sides, at least in the commercials, in a commercial dispute, if there is a resolution process, then definitely the domain expert to whom the parties have gone to can help in identifying the mediator. Because the mediator can identify who would be the best person to understand the dispute between the parties. So to that extent, yes, a domain expert will help in identifying the mediator. But let's assume if the dispute is sent to a mediation center and a non-domain expert is appointed as a mediator. In that case, the problem would be that obviously when a non-domain expert is a mediator, he goes by the process of mediation. Where a domain expert might feel that it's a time-wasting process, he might scuttle the mediation. So in that case, a domain expert has to sit back and let the mediation process evolve. Now the question is, where would his expertise be of use? Now, in disputes, there could be certain areas which probably the mediator is also not aware, also does not know what would be a solution. At that point of time, though it is antithesis to the mediation, but something which can be practically done is where the domain expert can tell the client the solution which he is looking for, which would be an eye-opener for the mediator to explore that area. See, at the end of the day, when, as we were told in Manesar, the best alternative or the worst alternative, the domain expert would know for the case which is the best alternative and what is the worst alternative, which would help the party to probably achieve what is the best for him and leave what is the worst for him. It will also help the mediator probably to give more possibilities of settlement. Because ultimately what is mediation? It is a guided negotiation process. In the matter of guided negotiation, a domain expert in a typical matter can give suggestions for the mediator to achieve the solution. And the most important part is where the settlement is to be drafted. The domain expert would know the pitfall of a particular settlement, the way the settlement has to be enforced, what not to be put in the settlement agreement, which would, or what to be put, which would sort out future problems that can arise in the solution. And therefore, the domain expert, if he knows mediation and the process of mediation, would help in coming to solution. For example, a builder and a buyer relationship. Now, it could be that the buyer wants the house, he doesn't want compensation. He might agree for a higher amount, some more time to be given, provided interest is reduced. It's something a domain expert will know. Or the field where Naveen is an expert, between an MSO and a cable operator. The cable operator wants the signals at any cost. The MSO is already, you pay the money in a few more installments. I will not cut your signals. Now my domain expert would know how to negotiate the settlement. And ultimately to draw something which probably his client, who might be a channel operator, might not get stuck with other cases. And so a domain expert, yes, he would be of an extreme important use while in specialized field of mediation.
Thank you. At least I was expert in one field. All right. Now this brings me to the next question, and I'll address it to Justice Sadeva because he's the chairman of the committee. And being the most controversial subject, I think it should be addressed to him and he elicit his answer. The controversial subject being that now with the mediation gaining so much popularity, and in fact the government coming out with the Mediation Act, so many lawyers becoming mediators, do you think that there is now a time to introduce ethical code of conduct for the lawyers, mediators?
So this question is posed not to me as a chairperson of the Samadhan, but as a domain expert on legal profession, because I used to be the lawyer for Bar Council on ethics for lawyers. You see, there are no special different ethical conduct. Same ethical conduct will apply for mediator lawyers. Because ultimately, as a lawyer, your first duty is to the court. Similarly, as a mediator, or even for mediation advocacy, your duty, if you remember that the ethical duty required is to the court and to upholding justice. That is the first and foremost ethical conduct that is required from a mediator, lawyer, or even an advocate for that matter. You have to be fair to both sides. In court, of course, one would have an intention of winning the case. You may in court sometime take steps which are within the comforts of law and not unethical, but maybe unfair to the other side. As a mediator, or as a lawyer appearing in the mediation process, you have to be fair to both. Because ultimately you have to achieve a result which both sides agree to. And sometimes we've seen that the parties which come in mediation process trust not only the mediator, but the other side lawyers also. So if you've done something unethical, which the other side feels, look, he's not dependable. So any suggestion coming from the lawyer of the other side would be taken with a pinch of salt. But if that party has confidence in the lawyer on the other side, or even the mediator, though mediators don't give suggestion, but they sort of guide parties. But if a suggestion or a question comes from a mediator, party would feel, yes, let me think about it. Maybe this is a fair suggestion. So ethically, all you have to be is fair. True to the case, true to the profession. Again, the settlement has to be correct. Now, taking it back to the question that you'd asked Justice Prasad about domain expertise. You see, now earlier we've been told that, look, what you need is mediation skills. Whether you have domain expertise or not really doesn't matter. But now, over the years, as mediation is becoming a specialized practice, we are realizing that some fair knowledge of domain subject is also important. A very basic example. In a matrimonial dispute, when it comes to a mutual divorce, person who has no knowledge about, say, Hindu Marriage Act, would even write in a settlement, look, parties will go to court, take a mutual divorce, and that's the end of it. And all payment will be made when the mutual divorce happens. What they will overlook is that there is that time gap of 6 months to 18 months. If you have no domain knowledge, or if you have somebody as a mediator who has no knowledge about this, then there could be an error, an unenforceable agreement. So some basic domain knowledge, if not an expertise, may be necessary. So when you are going in as a lawyer in mediation process, or as a mediator, apart from being fair, one tip would be, please do a little bit of study on that subject. Because the role of a mediator is not to guide. It's like a mediator training, like a parent seeing the child learning to walk. The parent would not guide the child where to go. When the child starts to walk, the parent would let the child explore and only be there as a sort of a safeguard to prevent the child from getting hurt if the child falls. So as a mediator, if you have domain knowledge, you would ask pertinent questions about that to the parties so that they realize their plus points and the negative points of their case by the questions put by a mediator. So ethically, be fair. Do a little bit of research on that domain subject if you have no knowledge about it. And of course, use your mediation skills to guide the parties to come to a negotiated settlement.
I see that Justice Deva gave a very broad answer to be fair, but did not tell us that whether he is going to come out with an ethical code of conduct for the mediators or not. But then, coming back to Justice Shakdar, because he's the one who proposed that one has to sell mediation process. Now, you sold the mediation processor, but you don't really know what that process actually is. So, do you think that for a lawyer also, who does not really, he does not practice as mediator at all. He's not had this trained mediation sessions, nothing at all. But as a lawyer, each lawyer must know the mediation process, how it is conducted, what are its various stages for it to become a success.
Yeah, you're right. But let me just clarify. When I said, you have to sell mediation, I meant it in a broad sense. In a sense, it's a sale without any consideration. You're actually, don't get me wrong, and you start...
Not at all.
you're actually in the business of persuasion. Even as a lawyer, you get fee for appearing in a court, but you're in the business of persuading the court. Ultimately, the decision lies with the judge. He hears two sides, he gets persuaded by one or the other, or he has his own persuasion and he carries on a third route. But to take, as they say colloquially, a horse to the well, you need to tell him that there is water or there is hay at the end of the road, and therefore you please go that path. Now, as far as this part is concerned, this can be done, let's say, with more ease if the lawyer himself is exposed to this process. So one of the ways is that we have a mediation center. The mediation center should actually hold, small, maybe conclaves, not conclaves, some meetings of lawyers in bunches where they do a half an hour, 1 hour program and tell them what the mediation process is all about, so that then they in turn can speak to their clients, and it facilitates that process. The other is actually, if you don't get that kind of time, you can make some kind of videos of the process itself, where we have these very, very experienced mediators like Mr. Rajiv Vermani, Ms. Reena Rali, the others who have been doing this for years, Mr. JP Singh, that they make these videos and explain what the process is. And if the lawyer doesn't have the time, he should ordinarily have the time because he's getting paid, he should actually ask the client to visit that site and see what are the processes that are followed. As I said, and I keep repeating that, and I increasingly believe one of the things, especially when the dispute is interpersonal, if it's not a commercial dispute, the litigants often ask you, what is my fault? What you need to tell them is, the mediator doesn't do that, the judge will do it, because he will necessarily have to decide and take a judgment call whether A is right or B is right. I'll give you a little example. The other day we had this matrimonial case where there was a dispute obtaining between the husband and wife. They had been separated for a decade and a half, and she went through first part of a dissolution of marriage by mutual consent. Those who are in that field would know that you have a first motion and a second motion, which was just referred to by Justice Sachdev, that you have to give it a 6 months period. She went through one part and she didn't go through the other part. When I said, listen, therefore there was some kind of a makeup that you can't live together, can we then send you back? She said no. And finally, as it transpired, the husband, because that other process was given up, filed a divorce petition, and he got a decree of dissolution on the grounds of cruelty. She said, well, I was never cruel to him. So I tried to convince her that, no one is judging you here, at least not now. And if you go to a mediator, even he will not judge you. You will have to find your own peace resolution in your own way. You're right, the husband is right, and therefore the mediator will only resolve the other issue, even if you separate, as to what alimony, if any, that has to be paid. So this aspect of persuading the client that the mediator is not judging you is very important. It's core and central to this process. You are the persons who are finding the solutions. All that he perhaps does is identify the disputes. And one of the best examples, and some of us remain unaware of this, is even between countries. The Bhagliar dispute between India and Pakistan regarding sharing of waters has been on since 1960. We've drawn up a treaty called the Indus Water Treaty, which has survived 5 wars between Pakistan and India. In fact, there was a very scary suggestion when the last skirmish happened that we should stop, we should renege on the treaty, and we should stop the water. Because we are on social media platform. But mediation is such a wonderful thing that even with your foes, you can arrive at a settlement which can survive other peripheral disputes. So I think that's the way to go about it.
Yes, that's absolutely good. So now my question is to Justice Manmohan. As Justice Shagdar said that one of the ways of informing the mediation process to the lawyers is through having those small seminars or some videos circulated. But I think by the time we've already entered the profession and started on our advocacy, to then get this further process or further inputs about mediation can become difficult. Do you think that we should start inculcating this study in the law schools itself so that the new generation which is coming in knows what the mediation process is, what are its advantages, how to approach the mediation process itself?
Yes, I agree that mediation should be taught as a subject in all law schools. And I say this for a number of reasons. Firstly, mediation is at heart an alternative dispute resolution mechanism. So in law, when you're teaching all subjects, you must teach the alternative dispute resolution mechanism. The second is that a lawyer is ultimately a service provider, and he must have all the skill sets available with him. And one of the important skill sets is with regard to mediation. Thirdly, I also believe, and that belief has got a bit fortified after being a judge for so long, that there is a lot of acrimony in the society. And this acrimony in the society needs to be resolved. People who undergo the training of mediation, or the lawyers who also undergo this process of training in mediation, they develop a skill set not only to deal with their clients, but how to deal with daily issues that arise before them. So according to me, it's a great skill set for any human being to have, leave alone just a lawyer. The other is the Bar Council has also recommended a 45-hour training in the law schools. I think that is also very salutary. And the training should be comprehensive. It should be theoretical, it should be practical, it should also include training. And that could include some sort of a collaboration with Samadhan. I think that also can be done because we have a wonderful, as Justice Shagdar said, we have a wonderful team of mediators who can guide them through this process. So that will be also a great experience for all of us. And I also believe that we must catch them young. See, catch them young, you'll be able to train them much better. Their vistas will be far broader. And Justice Chawla, why do you think only at the law school level? I would suggest it should be a part of the curriculum even in 11th and 12th.
Correct.
Because that's a great skill set to have as a human being. So I would like to even start younger if I had my way. So I think it's important, it is imperative that we start with this process as quickly as we can in the law schools at least.
I totally agree with you, sir, that it's not really a dispute resolution mechanism, but mediation is actually a skill set which one needs to acquire to get that calmness and to understand what the underlying dispute actually and ensure that that dispute never arises. It's a very good suggestion that it should actually be at the school level. While we may like to go on, I'm sure the judges here want to go back to their chambers and finish their daily orders and read their next day files. And the lawyers want to go to their chambers and earn their money. So I think we'll call it quits here. And thank you very much for your
I think we need to thank Justice Chawla.
No.
Yeah, I must say that Justice Chawla is very reluctant to come to any of these, meetings. But today he was caught.
So today I had to listen to the thought and the guidance of the seniors, and that is why it was a real pleasure to be here.
Thank you, Justice Chawla.
Well, I'll now hand it over to Mr. Virmani too.
So we called Justice Chawla young.
If you still call me young, thank you.
You are young indeed. So that was quite an insightful discussion, and we carry home a lot of messages. We would like to tabulate it and present it to all our mediators. I've made notes about what we have discussed. As you mentioned that you have to go back to the chamber, I'll request Anita to please come forward and present a vote of thanks.
Good evening, everyone. Honorable the Acting Chief Justice, Honorable Judges gracing the dais, Honorable Judges gracing the occasion with their presence here, Mr. Chetan Sharma, Additional Solicitor General, Mr. Mohit Mathur, President, Mr. Jatan Singh, Vice President, Mr. Sandeep Sharma, Secretary, dear members of the Executive of the Delhi High Court Bar Association, my senior colleagues, mediators, advocates, and friends. Being a member of the prestigious Samadhan family, it is my pleasure and privilege to propose the vote of thanks on this occasion to inaugurate the calendar for the year 2024, culmination of tireless, continuous, and committed efforts of Ms. Veena Ali and Kiran Kalra. Followed by the Symposium on Mediation Practice and Advocacy, Embracing the Change. It is said by William Arthur Ward, feeling gratitude and not expressing it is like wrapping a gift and not giving it. I would first like to thank the Honorable Acting Chief Justice for taking out time to be here from his busy schedule on a Tuesday in the middle of the week. Sir, your support and encouragement is with us to take us forward. Next, I thank our speakers, Honorable Justice Rajiv Shakdar, Honorable Justice Sanjeev Sachdeva, Honorable Justice Naveen Chawla, and Honorable Justice Subramanya Prasad for their immeasurable contribution this evening by way of such a rich and discussion on the topic, which is so relevant and real to us. My gratitude to the Overseeing Committee of Samadhan for their unwavering support in each sense of the word, to propel and encourage us to continue to be part of this movement, which started way back in 2006. I would also like to thank Mr. Rajiv Virmani for anchoring the program this evening. Now I thank the team of Joint Secretaries of Samadhan to have put their joint efforts for the evening. I thank the Registrar General, Delhi High Court, for all the support to host today's program. Next, I thank the Registrar Mediation and his team for their sincere efforts in putting together the entire program so seamlessly. A big thanks to Mr. Mohit Mathur, President, Mr. Jatan Singh, Vice President, Mr. Sandeep Sharma, and the members of the executive of the Delhi High Court Bar Association for standing by us each time that Samadhan has held a function. I would be failing in my duty if I did not express my gratitude to the staff of Samadhan who are working round the clock despite the tempers running high from parties and the council, which I have witnessed myself on many occasions. The technical team deserves a special mention, without whom we could not have heard ourselves. Last but not least, I would like to thank all the invitees present here, accepting our invitation, and each and everyone who worked behind the scenes to make this success. Once again, thank you all for your attention. Till we meet again. Please join us for tea in the lounge on this very floor. Thank you very much. Good night. A photograph is requested with the joint secretaries. Is that so? I'm sorry for holding you all from your work. So this is a team of joint secretaries of Samadhan. And also the organizing committee, please. Mr. J.P. Singh, Mr. Batra, Mr. Virmani. May I also request Mr. Mohit Mathur, Mr. Chetan Sharma, Mr. Jatan Singh, Mr. Sandeep Sharma, Secretary from the Bar Association. I thank you all for your patience to be here. I happen to be one of the joint secretaries as well, remember. Please join us for tea in the lounge. Thank you.
उनसे सुना है प्रोफेशनल से रियली क्या बात है छा गया ऐसी नहीं ऐसी
मैं आ गई बात जो मुझे याद है मैं भी देख गया
बात तो याद है
Your vote of thanks has restored the position of vote of thanks.
I know.
Are you getting what I'm saying?
After sir. After sir.
You have not got it. You got it?
मैं नानी खड़ा सी हूँ